All right, so moving on. So preventing discrimination, discriminatory practices, restricted policy. Do HRM activities result in exclusion of group of individuals, right? And geographic comparison. Does the company's mix of employees at all levels reflect the recruiting market? So if you reflect the community, all right? Are you, if you live in a state that is predominantly Black or predominantly Asian, predominantly white, then I would expect to see more of that predominant race. But if you live in a state where you have a even mixture, then your employment strategy in terms of recruiting persons should be ensuring that you get persons of mixed races, right? Women as well as men. Once your job requirement, a job specific requirement does not interfere with, like for instance, height, as explained earlier. The McDonnell-Douglas test. 4 components must exist. Individual is a member of the protected group. Individual applied for a job where he or she was qualified. Individual was rejected. Employer continued to seek applicants with similar qualifications. So that is another factor that will qualify for discriminatory practices. Okay, so just to recap, we're using these 4 tests to determine if discrimination has occurred. So we have the 4/5 rule, we have the restricted policy, the geographical comparison, and the McDonald's test. All right, so affirmative action. Seek to correct past injustices in hiring by actively seeking minority applicants. So persons would have been found guilty of discriminatory practices in employment, and what they can do is actively seek the minority group. So there's the group that they discriminated against and employ those persons in order to correct their error. Workforce should resemble the community. Applies to organizations that contract with federal government. Enforcing equal employment opportunity. So you have the federal government, you have the EEOC, you have the OFCCP within the DOL and the state laws. All right, this is not very critical for you to know, it's just for you to understand that there is a structure in place. Now, Equal Employment Opportunity Commission. It enforces the title at 7 and other legislation that cover charges of discrimination based on race, color, sex, national origin, age, or disability, because you can be discriminated against due to a disability. Five presidentially appointed commissioners, significant backlog of cases, right? All right, so there's a complaint procedure for enforcing equal opportunity employment. The charge must be filed within 180 days of the alleged incident. The organization is notified by the EEOC within 10 days. Investigation begins. EEOC notifies the organizations of its finding within 120 days. And if they find the complaint is unfounded, the individual may request the right to sue in civil court. If complaint is justified, the EEOC works with the employer to correct the problem. If resolution cannot be reached, then EEOC may sue the organization, and they will be doing that on behalf of the person discriminated against. So we also have Office of Federal Contract Compliance, ensures that the contractors doing business with the federal government do not discriminate and take affirmation action. Follows similar practices of the EEOC in evaluating the claims and can cancel an organization's contract with the federal government if it fails to comply with the EEO laws. Now, we also have sexual harassment. Sexual harassment is actually something that you will be tested on, right? Sexual harassment creates intimidating, offensive, or hostile working environment. Unreasonable interferences with an individual's work adversely affects an individual's employment opportunities. Sexual harassment can take 2 forms, right? The behavior is expected as a condition of employment. So you go on an interview and you're touched or spoken to in a manner that it's an unwanted sexual advance, and it says, okay, if you do this, then I will employ you, right? That type of, so that's one type of sexual harassment. It's called a quid pro quo harassment. And then you have hostile environment harassment. Workplace environment is often offensive enough to interface with the ability to work. So your coworker comes over your shoulder, they're breathing on your neck, they're touching you inappropriately, they're looking at you, you know, in a manner that makes you very uncomfortable, because sexual harassment has to do with unwelcomed sexual acts. Now, that hostile work environment, it happens all the time. A lot of persons do not understand that they're actually committing sexual harassment, and sexual harassment in Antigua and Barbuda is against the law. So it's a reportable offense that the police will handle, right? The law takes it into their hands. Employer steps to create a workplace free from intimidation and sexual harassment. Issue a sexual harassment policy describing what constitutes harassment and what is appropriate behavior. Institute a procedure to investigate harassment. So you should have a sexual harassment policy, and you should have an incident reporting procedure for sexual harassment. So if it happens, you have a programmed response to it. Inform all employees of the sexual harassment policy. Furthermore, you need to train management personnel on how to deal with harassment charges and what the responsibility they have. You need to report that right away. It's a matter that should not even stay on the level of the organization. The individual who was offended should be asked if they'd like to get the police involved, and the police should be informed so that they can investigate it, because sexual harassment is a very serious offense. So again, you investigate all harassment charges immediately. Take corrective action as necessary. Continue to follow up on the matter and ensure that no further harassment occurs or that retaliation does not occur. Periodically review turnover records and determine if a potential problem may be arising. You may have a manager who you would have had complaints against, and then you'd realize that, okay, some employee and persons are resigning, and you're wondering why. Don't forget to privately recognize individuals who bring these matters forward. And you need to also protect the individual, right? Because they may be targeted. So current issues in equal employment. Comparable worth. Jobs of equal importance to an organization should earn equal pay. And we would have discussed this in class. Factors to consider would be skills, responsibility, working conditions, effort, and skills would include your qualifications. We also spoke about that glass ceiling effect, that glass ceiling, that the lack of women and minorities at top level. So that is a real problem that we need to be mindful of, and employers need to ensure that in practicing equal employment opportunity, this is not taking place. Sexual orientation. So current issues, again, we're dealing with current issues in equal employment. So we have sexual orientation. No federal law protection. 21 states, the District of Columbia, and federal government prohibit discrimination based on sexual orientation. So there's no federal law, so it means it doesn't apply to the entire USA. All right? English only laws. Necessity must be proven. It may violate national origin discrimination protection. Appearance and weight. No federal law protection. Again, it means that it is not the same all over the US. It's only the states that would have adopted it. Discrimination may affect pay, hiring, and promotion. All right, so HRM in the global environment. So these are just some information related to the different countries. For instance, Canada, law similar to US, but law comes from provincial level, right? So these are some of the laws that they have on the global environment that if you have the time, you can take the time to just examine it, because you don't know where you'd end up in your career, and it's always important to know what exists. So let's do a little fill in the blank. All right, so you can do this on your own because it's no fun since you're not here. But again, so the Civil Rights Act, Title 7, protects individuals on the basis of Race, color, religion, sex, national origin. Equal Opportunity Act established the EEOC. Civil Rights Act of 1991, it's included the glass ceiling. Four-fifths rule speaks about that 80%. And with business necessity, companies argue job relatedness in responding to accusations of discrimination. So if it's a job-related issue, you can defend that claim that you discriminated. And last but not least, the cases that comes from the cases, right? And it ruled that tests must be fairly measured, measure the skill and knowledge of the requirement for a job. All right, so this takes me to the end of this chapter. There's one more. Again, you can do it on your own. And then I'm going to now move on to the next PowerPoint, which is chapter 4. All right. Okay, so I'm going to go through this quickly. All right, so this chapter is about employee rights and discipline. Our learning and job objectives include explain the employee record keeping responsibilities and laws related to keeping and collecting employee information, discuss employer concerns about social media use and the components of an effective social media policy, identify current issues regarding employee rights, explain legal and ethical issues involved in monitoring employees in the workplace, discuss the implications of the employment at will doctrine, and identify exceptions to it. Explain the elements of effective discipline policies, identify important procedures to follow when firing an employee, and explain how issues of employment relations differ in global environments. So HR protects the rights of the employers and the employees, because remember that HR is that bridge between management and staff. Rights are evolving due to societal changes and expectations, new technology, and court decision. When a court decision is made, it sets a precedent for the precedents for future cases. Employee relation involves employee rights and discipline, establishing culture. When we've spoken about culture, effective communication, motivating the workforce, labor relation, and collective bargaining. All right, so the HRIS system store records and as the information system, allowing employers to be more efficient and to go paperless or nearly so. Department of Labor set guidelines for keeping employment records, usually for 1 year. All right, and these are a list of all of the things that may be kept electronically. Privacy Act. So there's a Privacy Act in the US, and that Privacy Act is of 1974. It requires the government agencies to make information contained in their personal files available to employees. Employee can review letters of recommendation made on their behalf. Similarly, the state law apply to the state and private sector employees. So that's not just for government employees, it's also the same for private employees. Restrictions, employee waivers of right to review procedures that stipulate when and how a file can be accessed, right? So the employee has that right. The Credit Reporting Act of 1991 requires employers to notify employees that their credit is being checked, provides additional information to applicants who are negatively affected by a credit check, and information must be job relevant. There's a Drug-Free Workplace Act of 1988, and it requires government agencies, federal contractors, and those receiving federal funds of 100,000 or more to establish and disseminate drug-free policies. So once you fit those requirements, you have to do that. Provide substance abuse awareness program, because you can have policies, but if you do not have programs to support those policies, it's not going to be very effective. Now, drug-free policies must include what to expect from the employees, the penalties for infractions, as well as the awareness programs. You have also a Polygraph Protection Act of 1998. There are companies, even in Antigua, that perform polygraph on potential employees and even current employees. It may be a job requirement, but that can only be applied after you've successfully completed the interview process and so on. So it prohibits employers in private sector from using lie detector tests in all employment decisions. It may still be used during investigations for suspect criminal activities. Employees can challenge the results of the polygraph, right? They can challenge results. So it cannot be issued before employment. It cannot be a condition for employment, right? You can be terminated, but the employee can still challenge it after employment. Worker Adjustment and Retaining Notification Act protects the employees from unexpected plant closing. Organization of over 100 employees must give 60 days notice if closing a facility or laying off 50 or more workers. You can't just lay them off. You have to give notice, or you would have to pay in lieu of notice. State officials must be notified. Penalty for not notifying is 1 day's pay and benefits for each day's notice. Now, social media. Employer rights are evolving through court cases. Discussion of working conditions on social media sites with co-workers is generally protected. Angry rants and name calling on social media are not usually protected. So you can't just go off on the employer on social media. It's not protected, and in most cases you would be terminated for something like that. Organizations need to establish a social media policy and inform employees of the policy, because in order for you to comply with the policy, you would need to know what the policy is. Public sector government employees have limited protection for online information. In private sector, employees have very little protection. Employees can discipline or fire for online rants and videos, and it has happened. Several cases have been passed and the employers would have won. National Labor Relations Board recognizes online communication as protected concerted activity if the communication was directed at other employees, employee was addressing terms and conditions of employment, or other issues that could be interpreted and union related. So they have conditions under which it is protected. Social media policies should include companies' policies regarding the use at work and away from work as well. Employee privacy expectations when using the company's internet, guidelines for being respectful to the company clients, company expectations regarding employee use of the company name and symbols, and legal repercussions of defamatory remarks, use of privacy settings. So all of these should be outlined in the policy. Okay, so drug testing, approximately 80% of the US employers conduct drug testing, and it's necessary because drugs have the ability to interfere with your cognitive abilities, right? And depending on what job you're in, the person can be at risk, as well as your employees can be at risk, your customers can be at risk. So it's an important thing to do. For current employees, offer rehabilitation to those who fail and communicate that drugs will not be tolerated. For applicants, should be done after the job offer is made. So only after the job offer is made, you can have such an invasive procedure. Those who fail are usually no longer considered. My apologies, I'm having a bit of a computer glitch. All right, so, current issues regarding employee rights. Under the Drug-Free Workplace Act, all individuals with federal contracts or grant, and the organization with federal grants or contracts over $100,000 are required to actively pursue a drug-free workplace, which means you're going to have policies, you're going to have programs, you're going to have tests. This act also requires employees who hold certain jobs in the company to companies regulated by the Department of Transport and Nuclear Regulatory Commission be subject to drug testing. So it's a condition of employment. Honesty and integrity tests designed to prevent theft, violence, sabotage, disciplinary problems, and absenteeism. And in order to ensure if you have a business and you're managing your business and you want that business to be successful, it's up to you as the employer to put things in place in order to protect your investment, right? So you assess honesty and trustworthiness and dependability. And that can be even done in the interview process. You can actually have strategic questions placed on the application, and it can test employees. Or after a job offer is made, they can go through a series of tests which would tell you about their disciplinary issues, absenteeism, and these are done by psychologists who study people and human behavior. So the tests usually work. You have things like DISC assessments, which would assess your personality to see if you're actually going to fit into the culture. Typical tests have multiple questions on the same topic to assess consistency of responses. So they may ask you the same thing 5 different ways. Whistleblowing. Employee notifies authority of wrongdoing in the organization, right? And you also have an act that would protect the employees from employer retaliation. Some state laws protect the job of the whistleblower as well. So if you are the whistleblower, it would actually protect you. All right, so current issues regarding employee rights. Workplace romance. Concerns include favoritism, ethical issues, low productivity, moral problems, workplace violence. And some policies would have what you call a fraternization policy and non-fraternization policy. And you would have to sign consent forms and you'd have to disclose your relationship. If it presents a conflict of interest in some cases, they are going to ask that you voluntarily resign from the position. All right, options include forbid co-worker relationship, right? Fraternization policy, or you require consensual relationship contracts. Off-duty behavior. Employee protection from disciplinary actions based on off-duty behavior similar to those listed earlier for social media. Public sector employees have some protection. Private sector employees have little protection. Some states like California provide more protection for private sector employees, and legalized or decriminalized marijuana laws vary by state. So you may have a code of conduct document that you may need to sign when you're employed, and it may prohibit certain behavior even off duty. Right? And then the employer can decide you're not representing the company well, you are probably the face of the company, you hold a particular position, you may do something in your uniform, and they may decide to terminate your contract. Off-duty behavior. Legalized and decriminalized marijuana laws vary again by state to state, right? So smartphones and social media allow employees to share off-duty behavior in a very public way. Employee monitoring and workplace security provide protection from security breaches, theft, revealing the trade secrets of competitors, using customer database, loss of productivity. So you can actually monitor what is happening using cameras, using online detection systems and monitoring systems in order to protect your customers, your employees, yourself, right? So technology provides effective ways to monitor employees, effective ways for employees to, and effective ways for employees to be dishonest. So you need to be able to monitor your employees in a lot of cases. But more importantly, you need to build that culture of trust and train your employees so that they know what is expected, what is accepted, what will not be tolerated by the company, so that you do not have to invest so heavily in monitoring. Employee monitoring workplace issues. Companies must make clear policies on what is acceptable and what is not when monitoring the employees. And you want to ensure that your place of work is conducive for productivity, creativity, innovation, and not make it so uncomfortable that the company suffers. Right, so the monitoring policies may include things like the use of the computer, internet, phones, password security, employee and employee rights regarding privacy, and use of offices, lockers, companies, vehicles, rights to search, appropriate internet use, and prohibited uses such as gambling, porn, discrimination, defamation, or other legal purposes. Privacy of trade secrets, customer, proprietary, or financial information. Somebody's credit card information, or how much profits we made last year, or what's our usual sales like on a particular day, right? Requiring employees to use personal devices for work create privacy and security problems. And that is why I am one for not using my private device for work, because then if there's a breach here, it creates an issue, okay? All right, so monitoring may include many types of employee communication as stated here, all right? So your emails, social media, professional websites. So employment at will, and I think I would have spoken to you about employment at will, allows dismissal of employees or employers to terminate the employment relationship at any time for nearly any reason. Exceptions for this would be discrimination. You, the employer, does not need a reason. So unlike Antigua, after you're hired for 3 months as a core employee, and you should know what the core workforce is, you don't have a contract, you're not part-time, you don't have any special agreement, so you're just employed, and 3 months passes or 90-day passes, the employer needs a valid reason to let you go. In the US and most states, you have what you call employment at will. And that employment at will means that you can walk into the job today and they can tell you they no longer require services. The only exception is if you can prove discrimination. Exceptions for employment at will, a contractual relationship, right? So if you have a specified contract to say it's for this amount of time, then no. Employed employment contract, a verbal or written statement that promises job security. So you have to be able to prove that. Statutory considerations, state laws, public policy violations, breach of good faith, constructive discharge, right? And so those are the exceptions for employment hours. So under those conditions, you can dispute your termination, right? So discipline and employee rights. Employees conduct themselves according to organizational rules and standards. They know what is expected. They know meeting those expectations is in the best interest of themselves and the organization. HR managers, and as future HR managers, as future managers, as future leaders, you should consider the seriousness of the problem, the duration of the problem, right? How long has this been going on, and how often, and what is the nature, right? Are there extenuating factors to consider? The degree of socialization, the history of the organization, discipline practices, right? And management backing. So when you're disciplining an employee, all of these have to be taken into consideration. Disciplinary action should be corrective rather than punitive. So if you decide to discipline an employee, it should not be to punish them. It should be to correct them so that it does not take place in the future, right? And I've had instances. I remember one time a team member left chemical in a water bottle in a room, and I had to discipline him. But rather than say, okay, you're suspended, it meant calling him to a meeting, explaining the importance of labeling chemicals, the potential hazards that it could have caused as a result of doing that. And then training, rather than sending him home. So he was not suspended, rather training was provided for him and all of the other team members, because it could mean that there was a lapse somewhere, right? So it should be corrective rather than punitive. All right, so the hot stove rule. Immediate response, so when you're dealing with discipline, immediate response, advance warning, consistent action, and personal application. All right, so this is just a case. Not going to go through those details with you. All right, so then progressive discipline steps have increasingly severe consequences. So verbal warning, usually start with a verbal warning, then a written warning, then a suspension, and then a dismissal, right? Or you may have a conversation and you have what you call is a note to file, and you may just note that this discussion took place, right, as a record. So it's not disciplinary, but it's just a note to file, to record what has taken place. Now, depending on the severity of the offense, one may move to suspension on that first offense or even dismissal. Your company, it's important for companies to have a grievance policy so you know exactly how to handle different disciplinary issues. Dismissing employees. When firing employees, you need to review all the facts. Set the stage, be very, very clear, allow a little dignity. You don't want to humiliate the person. Let the employee talk because you need to hear what they have to say. Give severance pay if the policy allows for that. Sign a waiver of rights to sue for wrongful termination. So once you're terminating on the good grounds, make that clear and you can have that waiver signed. Pay for the time earned, be honest. Have the person leave that day. You don't fire somebody and then you tell them, I'll come back tomorrow and come back, no. Right? If you have to let them go, have everything prepared to do that. Take protective steps. You want to change passwords and so on, and inform the staff of firing, right? All right, so employee relations in a global environment. Employment at will does not exist in many countries, making dismissal of employees difficult. It doesn't exist in Antigua. Employment at will does not exist in Antigua. So it's strong in Europe. And then you have the strength of unions varies. It's strong in Europe and weak in China. And it speaks to the cultural clusters that we would have spoken about, right? All right, paid time off. Many countries offered paid time off, as in Antigua. A lot of the countries in the US not necessarily pay for time off unless it's required by law. And if it's not required by law, so you have maternity leave that is paid for in Antigua, and then you have paid leave for all workers, which is speaking to vacation days, which is also paid for. All right, so you can go through these questions and answers just to give you a little hint on the study. So the previous